I'm looking at this old case from the days of the Soviet Union. Tokarsky versus Tokarsky. O versus V. 1971. O. Tokarsky sued V. Tokarsky to void a will and a contract of gift and to divide an estate on inheritance, claiming that her father, D. Tokarsky, who died on July 20th, 1967, was seriously ill and unable to understand the meaning of his act on January 20th, 1964, when he executed his will, bequeathing all his property to his second wife, V. Tokarsky, and his minor daughter, O. Tokarsky, and when he executed a contract of gift on December 24th, 1966, transferring his dwelling to V. Tokarsky. The Moscow City Court gave judgment for ... You know, they made some changes a few years back to the rules of procedure in the state of Texas regarding certain municipal courts. It's something that they've been trying to emphasize more in the last few years. Municipal courts, what you do in the municipal court. It's kind of akin, I believe, to some of the other judicial changes that have taken place in the last 10 years. Attempts to bring up potential priority regarding the option of going before a magistrate judge in order to avoid the cost or potential complications with attempting to justify it as a jury trial or going through the processes of getting a jury. These are some of the changes that have been recommended and acknowledged, even implemented. I'm sure at this time they're debating the merits of certain policy pursuits over others, and they're doing everything they can to discuss and move on matters related to the discipline and otherwise functioning of the professionals involved. But I think we're due for a reconsideration of the legal definition of a mental competence. If you take it out of the stigmatization that usually goes with the attendant acts of defamation that have been traditionally allowed to determine competence or mental fitness or mental capacity. And what competence really says is that you have the conscious capability to handle the responsibilities that you allege and that you put forth to other people you can handle, especially if you're in a professional capacity representing somebody else, certified or licensed in a particular manner so that you can provide services or good faith and credit by virtue of your name or professional society when it comes to assisting other people with their resource needs. I've been saying for the last 3 years that I would not willingly submit to a psychological examination unless the person performing it could demonstrate their competence and verify it with an actual conversation with me on important matters, such as their understanding of the impact of electromagnetic frequency on neurochemistry, and their understanding of how artificial manipulation of hormones and biorhythms may impact somebody's capacity to respond to emotional stimuli. Additionally, they would have to demonstrate competence in understanding very, very basic cyber protocols and what would be necessary for an appropriate cybersecurity in order to distinguish between what is a unconscious urge that has not been appropriately refined through discipline or appropriate education? What is a willing refusal of the person to apply law or policy that they already know they are required to apply in order to be qualified for certain things they claim to be qualified for? And what is the technological infrastructure for torture and recruitment into acts of terrorism or other forms of psychological manipulation in order to try to compel someone to agree that they've ceded their sovereignty so they can be enslaved by somebody else? As far as I'm concerned, those are the most basic requirements in our modern society for everybody who alleges to be a psychological professional. Caseworker, psychiatrist, therapist, even peer counselor, especially depending upon who you would consider your peers. Now, if we're talking about people who are in a position where they may be required to make determinations in a situation wherein they understand they have command authority about applying techniques that might later influence what a psychological professional who is appropriately qualified and determined to be competent as a professional would have to consider in whether or not they decided somebody was mentally fit and they do not demonstrate that they have command in those regards, then I contend they also lack competence. And unless they admit that they allowed somebody else to write those orders for them, then what that says is they are incompetent in their position and they need to be removed from it. They lack the mental capacity to follow through on what they allege they're qualified to do. If you've determined and accepted and billed for and then covered up for and then created derivatives off of those billings that somebody was incompetent, mentally incompetent, whether it's through illness or insanity, and they protest, which they're entitled to do, and they prove, and then you cover it up, and you steal the evidence, and you sell it as a product, and year after year after year, you continue this farce, and then you get in command again, and you can't command. They're very important questions that need to be asked by the qualified professionals. And if we need a reconsideration of professional standards, then that's what we need. What we don't need is an entrenchment into attempting to sabotage and degrade those standards by allowing for there to be a manipulation of the processes whereby violations of the Constitution, specifically around slavery and peonage, can be masqueraded as if it's any other thing and allowed to be sanctioned under the authority of somebody that's mentally incompetent to be in their position.